My name is Professor Paul Brand, and I am going to say something about the BCL M. Jure option, Law and Society in Medieval England. And if you've never studied or even really considered legal history as an area of legal studies before, you might want to consider it as a possible option for you to take before you leave legal academic world altogether. The focus of the option chronologically is on the long 13th century, period from the last quarter of the 12th century through to the early 14th century. And there's a good reason for this focus. It's not just the particular focus of my interest, but it's also an important period of English legal history, because it's the period when we first begin to get the survival of professional, or the emergence really, it's not the survival, it's the emergence of professional lawyers. We also get the first emergence of judges or justices whom you can reasonably describe also as being professionals. It's also the period when we begin to get the survival on a significant scale of the official records of the main royal courts, which give us, albeit in summarised form, the arguments of lawyers or other legal representatives sometimes, but relatively rarely of the parties themselves, and the judgments of individual courts in particular cases. Added to that, we also begin to get, in the last 30 years of the 13th century, the first surviving law reports, which give us a much fuller version of the arguments made in court in the language that the lawyers actually used in court, giving us pretty much their words, and tell us which individual lawyers and which individual justices actually made those arguments. And these two sources between them allow us to see law in action, development of the English common law over time. It's also a period that we begin to have a significant amount of deliberate legislative change in the common law through statutes and other legislative acts. These start with Magna Carta in 1215. There is other legislation, important legislation in the 1230s and again in the 1260s, but the real takeoff in legislative change in English law is the reign of Edward I from 1272 onwards. We begin on the basis of surviving material to be able to answer meaningful questions. Why legislation was thought to be necessary or desirable, in whose interests it was made, and how it was interpreted in practice by the courts and modified or sometimes nullified by subsequent legislation and governmental action. And the main focus, but not the sole focus, of this option is on this legislation. That may sound a little forbidding, and it will sound even more so if I add that the legislation itself is partly in Latin, partly in Anglo-Norman French, and that the official records of the courts are in Latin, and the law reports mainly in Anglo-Norman French. But, and it's a big but, all the original sources that you will need are in fact available in English translation and will be made available through the website. For some of you, it may sound a bit forbidding that it is legal history, but a knowledge of English medieval history, indeed of any kind of history, isn't a requirement. All you might find helpful is to do a bit of preliminary reading on English political and social history in the 13th century. It will add to your enjoyment of the course, but it isn't essential. The course is taught by two of us. Mike Macnair, who will talk when I stop talking, is by origin, I hesitate to use the term, a straight lawyer. I am by origin a straight-ish Oxford historian. But when I worked on my thesis here in Oxford under the supervision of a lawyer who was also a legal historian, that began my transmutation into something of a lawyer and historian. And I've taught in law schools, and I've been around lawyers long enough to be treated with some suspicion by historians, and I've been around historians long enough to be treated with some suspicion by lawyers. And with that, I will hand you over to Mike.
My name's Mike Macnair. I'm, as Paul has just said, one of the tutors in the law faculty, and I'm the second tutor on this course. I bring to it, Paul brings to it the perspective of a specialist very much in period. I bring to it that of a longue durée person who teaches Roman law to first-year undergraduates and English legal history to third-year undergraduates and modern English law to first and second-year undergraduates. I'm just going to add a few other points. The first is that we, in relation to students who are taking the MJUR, Magister Juris, it might be imagined that you need prior knowledge of English law to study this course, but you don't. And the reason is, of course, because this is the period in which English law as such is constituting itself, is being constituted as a distinct legal tradition. And from that point of view, in fact, it's perhaps particularly useful for people who want to do comparative legal studies, because you're looking at the foundations of the common law, both in its peculiarity in the form of legislation, that it's highly technical, that it's tinkering legislation rather than making grand statements of principle, and in the form of the development of precedent and case law as a source of law. Secondly, a general observation about what we cover. We cover the law relating to the family, wardship, the peculiar regime under which the feudal superior had guardianship of the orphan children of tenants in military tenures, family settlements, lordship and ownership, the relationships between feudalism and property in land, property remedies, the enforcement of tenurial feudal obligations, contract and leases and agency relations, and debt obligations and the enforcement of credit relationships. These all interact, and in a sense, actually, when I've said a whole load of things which are about feudalism, and this again, we're talking about something it's not unknown that English law, English real property law, English land property law, property in land, has a substantial feudal aspect to it, even at the present day. And indeed, the Law Commission recently discussed whether to abolish feudalism, and decided that it would be too much trouble and not worth the effort.
And lead to difficult and unpredictable
consequences. So again, looking at this as a course, it's looking at the law and society of a society which is different from our own, but also at the same time at the foundations of certain peculiar characteristics of English law. Finally, in terms of methods, we teach, there will be fortnightly seminars running through Michaelmas term and Hilary term. There will also, if there are any significant numbers on the course, be tutorials where you write essays and discuss them with the tutor, and the final assessment will from this year be by essays written during the Easter vacation and submitted at the beginning of the summer term.